oh, yeah. Oh, yeah. Jaja, hear my plea.
Give me a rest, no salt mix. Every time me rise, I don't want you they praise. Give me a rest, no salt mix. And my time fi smile, and my time fi get blessed. Give me a rest, no salt mix. Every time me rise, I don't want you they praise. Give me a rest, no salt mix. And my time fi smile, and my time fi get blessed.
Many years of famine, many years of drought. I'm lost in a maze, but I have to get out. Now things have to change, no time for doubt.
Yeah, top of the morning. Just continuing our series on Jamaican Constitutional Review, starting on chapter 5, which is Parliament. Alright, going straight into it. Part 1. Composition of Parliament. Establishment of Parliament. There shall be a Parliament of Jamaica which consists of Her Majesty, a Senate, and a House of Representatives. Point 35. The Senate. The Senate shall consist of 21 persons who, being qualified for appointment as senators in accordance with this constitution, have been so appointed in accordance with the provision of this section. 13 senators shall be appointed by the Governor General, acting in his accordance with the advice of the Prime Minister, by the instrument under the Broad Seal. The remaining 8 shall be appointed by the Governor General, acting in accordance of the advice of the leader of the opposition by instrument of the Broad Seal. So that means basically that the Prime Minister, leader of the government, ruling party, gets 13 seats in the Senate, while the opposition gets 8 seats. So it's 13 to 8, which is what, 21? Yeah, 21 seats in all, right? Regardless of what election margin or whatever. 36. House of Representatives. The House of Representatives shall consist of people who have been qualified for election as members in accordance to the provisions of this Constitution, have so been elected in a manner provided by or under the law of the time being forced in Jamaica shall be known as members of Parliament. So basically, these are the people that we vote for during a general election to represent us in Parliament, members of the constituencies. And last time I checked, there were 66 MPs in Jamaica, and the majority of that would form the government. So if the 66 seats are divided in two, which is 33, they'd have to do a recount or probably go again in the election. So they might have changed it by now that it's uneven. Because one of the elections, recent election, was very close, that they lost by one seat and they have to recount the ballots. So that's how the government is formed, basically, by electing MPs, members of Parliament. 37. Qualification and disqualification for electors. Point 1. Subject to the provision of Section 2 of this section, a person shall be qualified to be registered as an elector for elections to the House of Representatives if and shall not be also qualified unless he is a citizen of Jamaica residing in Jamaica at the date of registration. So even if they're a citizen of Jamaica and their permanent address is not in Jamaica at registration, they're not eligible. Second point. A Commonwealth citizen other than a citizen of Jamaica who is a resident can also be registered to run in elections. For at least, they have to be living in Jamaica for at least 12 months and attain the age for running an election. I think that's probably 35. You can qualify. I have to double check that. No person shall be qualified to be registered as an elector for elections to the House of Representatives who is under sentence of death imposed by him by a court in any part of the Commonwealth or serving a sentence of imprisonment by whatever name called of or exceeding 6 months imposed on him by such court are submitted by competent authority of the same sentence imposed on him by a court under which a sentence of imprisonment, the execution of which is suspended or. So basically what they said, if you're on death row, or if you're doing a sentence in excess of 6 months, you don't qualify for running election and being a sitting member of parliament. Because I guess that would give you then diplomatic immunity, which would overrule that sentence. And yeah, it just makes a good logic basically. Second point is disqualified by such registration by law for the time being enforced in Jamaica because he has been convicted of any offense connected with the election of members of House of Representatives or any other local authority or body for local purposes. So if the temporary elections, they don't qualify. If they have any offenses laid against them against a member of the House of Representatives, they still won't qualify. Next point. Is under any law from time to time being enforced, certified insane or otherwise unjudged to be of unsound mind or detained as a criminal lunatic. So these persons that were sent to asylums are being deemed criminally insane or not mentally able to fulfill this job would also be disqualified. So this is just basically a legal terminology. This is how sometimes they argue when a member of parliament isn't suitable for that seat. Sometimes they say like they need to do a mental evaluation on them. That's how the politicians banter each other in parliament sometimes. Like they're saying this person's probably getting up in age and they have Alzheimer's and all of that. So this will fall under that part that they could get them out if deemed unfit. Alright, so next section, it says in this section, the prescribed age means anyone the age of 21 years. But I haven't heard of any 21-year MPs recently, but that's the minimum age of 21 or such age being less than 21, really. But not less than the age of 18 years. So 18, as long as you're adult in Jamaica, you are able to run. Can be prescribed a special act, meaning the Act of Parliament bill, which is prescribed by both houses, and therein each house has been supported by the votes of the majority of the members of that house. So unless you're 21, you can't run unless getting special permission if you're between the ages of 18 to 21 by both houses of parliament, by the House of Representatives and the Senate. Then there will be special provision for that person to be on the ballot. 4. A special act may be repealed or amended by another special act and in no other manner. So that's basically that chapter. Now we're going into chapter of electoral law. Not chapter, the part of that chapter within Parliament. So it says electoral law is 1. Any law for the time being provided for the election of members of the House of Representatives. It shall contain provisions designed to ensure that, so far as practicable, any person entitled to vote at an election of a member of House of Representatives shall have a reasonable opportunity of voting, and they should also contain provisions relating to the conduct of elections in the matter of members of the House of Representatives, including provisions relating to the identification of electors designed to ensure that as far as practicable, no person shall vote at an election of a member of the House of Representatives who is not entitled to vote, or when he is not entitled to vote, or where he is not entitled to vote. So if they're not entitled to vote, that means they're probably not a Jamaican citizen, or he is under the age of 18, or he is on a criminal charges probably, right? That's who. When you can't vote outside of the election window, so there are set dates when you have to vote, you can't vote outside of that time, right? And where, say you register to vote in parish, say Trelawney, and you live in town, in Kingston. You can't vote at a voting station in Kingston at that time. You have to vote where your vote is registered. So that covers basically those 3 points. No election of a member of parliament shall be called into question on the grounds that the law under which election was conducted was inconsistent with that section. Just know. Next point under this chapter of House of Parliament basically says the qualification for the members of Senate or House of Representatives. It says subject to the provisions of Chapter 40 of this Constitution, any person who, at the date of his appointment or nomination for election, is a Commonwealth citizen at the age 21 or upward, and has been ordinarily a resident of Jamaica immediately preceding 12 months, shall be qualified, appointed as senator or elected member of House of Representatives, and no other person shall be so qualified. So basically, it's just recapping what was said before, like eligibility. You have to be at least 21, and basically they should be a resident of Jamaica during the period leading up, because it would make no sense that a foreigner elected MP in Jamaica and they have no connection to the political landscape basically, because they wouldn't have the experience, they wouldn't know what to change, what to fix, what policies to veto, what to table. From afar, they would have to be on the ground basically, right? And what disqualifies a person from becoming a member of Senate or House of Representative, no person shall be qualified if they are a member of the Senate. They can't qualify to run for the House of Representatives because they are already a senator. They will be disqualified for election by law for the time being forced in Jamaica for the reason of holding or acting in any office function which is involved in responsibility for or in connection with the conduct of any election, or responsibility of compilation of revision of electoral register. So the electoral general, all those persons that are involved in auditing an election or overseeing an election, they cannot run for office at the time that they hold the office that they hold in overseeing elections, basically, because that would be conflict of interest, because they oversee the election could tweak the results that it suits them, basically. That would be deeper corruption. No person shall be qualified to be appointed as a senator or elected as a member of House of Representatives who is by virtue of his own act under acknowledgement of allegiance or obedience or adherence to any foreign power or state. So this basically comes into the dual citizenship argument that some Jamaican politicians had dual citizenship, mostly American citizenship, right? Along with Jamaican citizenship. And this is a breach of the constitutional responsibility that they have to not pay allegiance or obedience to a foreign power state. So basically, when you accept a United States citizenship, what you do is you pledge allegiance to the United States flag and anthem and other emblems as well in accepting that citizenship of the foreign power. Basically, what I interpret from this, by virtue of that act, is that if you're a member of the Commonwealth, it would be different based on the parts that came preceded this, because if you're a member of the Commonwealth, that means you would have pledged allegiance to the Union Jack, basically, which Jamaica also does. So there would be any conflict in that, but for a country like America or Canada, there'll be conflict there. Alright, so the second point is if the person holds an act in a public office or office of a judge of a Supreme Court or Court of Appeal or otherwise provided by Parliament or is a member of defense force of police, soldier, high commissioner, coast guard, court justice, DPP, Supreme Court judge, none of those persons are eligible to run for member of parliament because basically it's a conflict of interest because you have an executive arm, a judiciary arm, and a legislative arm. So a person from the judiciary, which is the court, the members of the court, couldn't run as an executive because that's a separate arm of the government. And the same thing for the legislative or the law enforcers. They could not run under the executive arm of government because that also would have been not necessarily conflict of interest, but it would have been a breach of the power that they have because they would have power under two aspects of the governance of Jamaica, and you want separation of powers to have a fair democracy, basically. See, next point is a party to or partner in a firm or director or manager of a company which, to his knowledge, is party to a contract with the government of Jamaica or an account of public service. So this is conflict of interest because if they have a contract, if they are a member of a company that has a contract with the Jamaican government, you could see how they could, in running for that seat, direct funds from the government coffers to that company and benefit their personal interests, basically. So this is how we prevent against that. But I would like to see what they would say about if they went in office and then they joined the company after, or maybe there's a part in the constitution which would prevent that. Is basically them from joining or applying that company while in office. Maybe they can only sit as an MP while being an MP, but that's just my speculation, basically. So let's see. Next point. In the case of appointment as a senator by informing the Governor General, or in the case of election of a member of House of Representatives by publishing a notice in the Gazette within 1 month before the day of election. Previously disclose the nature of such contract in his interest or interest of such firm or company therein. So I guess that could be combated by doing those things if they appointed upon informing the Governor General or the case that they had published a notice that they will basically terminate the contract with that company, having given them permission to run. And next point, subject to provision of subsection 3 of this section under the sentence of death imposed on him by a court or part of the government serving sentence of prison whenever name is called exceeding 6 months. So basically it's repeating what was said there, they would be ineligible that time. Or a person that has been declared bankrupt under the law in force in any part of the Commonwealth. So if a person is bankrupt, they wouldn't be deemed fit to run as a member of parliament either. But about the part of being bankrupt, a lot of these member of parliaments, they have their resources, but it's not transparent enough to know that their wealth that they use from day to day is actually theirs, or if they're living off a company's profits when the company is indeed in foreclosure or going bankrupt, or their personal funds, they're not using their personal funds because it's not that transparent of knowing. But I guess the electoral commissions would check the background of these persons. And the next point, under any law for the time being, enforcing Jamaica being certified as insane. So basically go through that. or if they're convicted, if they're convicted of the criminal insane, or if they're serving 2 or more sentences of imprisonment that shall be served consecutively throughout that time shall be regarded exceeding 6 months, they shall be ruled ineligible to run. No account shall be taken of a sentence of imprisonment imposed as an alternate or to deferred payment of a fine. So basically, if the sentence was not an imprisonment sentence, but it was just a fine, but because they failed to pay the fine, they were then imprisoned, it wouldn't be counted as an imprisonment imposed on the person because they basically serving time for the fine that they couldn't pay, and it's not viewed as the same offense, basically. So they could still be eligible to run. For the second point under this chapter, it says tenure of office of senators and members of House of Representatives. First point, the seat of a member of House shall become vacant upon the next dissolution of Parliament after appointment or elected. So there comes a point when the Parliament basically everything is just dissolved. Basically, in election times, whole Parliament is just dissolved basically, and the government, the country basically running on automatic. Basically, like the Prime Minister still has his roles and responsibilities and MPs and stuff, but they're not officially in office. But they basically just handle the affairs of the country in the interim, even after elections, before the new government is sworn in. Those ministers still somewhat handle their responsibilities before turning them over if they get voted out, but they are not officially still responsible for it. But they just want a smooth transition. So basically, most of the offices become vacant at that time. And if the person has resigned, the seat will also become vacant. If they're absent from the house in a string of period, like more than one time, such that it may be prescribed in the standing orders of the house. So if they constantly absent from parliamentary meetings, that's why they have a register. They constantly absent, they will be seen as vacant members, basically, they lose the seat. Or if that person ceases to be a Commonwealth citizen or takes any oath or make any declaration basically to acknowledge another territory's state powers, adopters, if they become while sitting members, citizens of another country and they pledge allegiance to that foreign state, they will lose their space in the House of Parliament or their seat in the Senate as well. If any circumstances arise that if he were not a member of House of Representatives would cause him to be disqualified for appointment of election, such as the points up above. So, if while that person is a member of Parliament, right, and they have a criminal offense, and that would have deemed them unfit to run, or they became bankrupt, they would also be stripped of that position. While a member of Parliament might be immune to certain prosecutions that charged against them might cause them to have to resign, basically, or they get fired. But most of the times what happens is they resign. So like corruption allegations, found guilty, they will have to lose their seat, or if they are found to be not deemed mentally or financially, they bankrupt, they would also lose seat. And the next point says if he becomes a party to any contract, so basically what I had hinted at, if while in that seat you become a party to the contract with the government of Jamaica or according to the public service, they will also be stripped of that position. position, provided if in the circumstance it appears to the Senate, in the case of a senator or House, to the House of Representatives, case to be just to do so in the Senate or House of Representatives may be exempt from a member vacating his seat under the provision of this paragraph. If that member, before becoming a party to such contract, was aforesaid discloses to the senator or to the House of Representatives, as the case may be, the nature of such contract. So basically, they have to be transparent about the nature of the contract, and everything has to be. It basically touched on that in the previous paragraph, but a lot of times I see they reinforce some statements in other sections and they reference the sections that were said before, basically. Or it said, if proceedings are taken under Section 44 of this Constitution to determine whether a senator or a member of the House has vacated his seat under the provision of this paragraph shall be declared by a court and have not vacated his seat if he established the satisfaction of the court that he acts reasonably was not aware that he was become a party to such contract. So basically, if they didn't know that they became a part of the contract and they can validate it in a court of law, they would not be stripped of the seat, basically. Next point. If any firm in which he is a partner or a company in which he is a director manager becomes a party to the contract, so basically any business or law firm, or if he's a director, provided that basically the same things that the point before, because it's gonna just, I can see where this is going. It's gonna go talk about the same thing. So basically, if you are a party to any business contract or any legal contract in which you have a relation with the government that will rule your seat, null and void, basically, in your seat. The seat of a member of the House shall become vacant if he is appointed as a senator. So you cannot be a senator and a member of the House of Representatives at the same time. Or any circumstances arise that if he were not a member of House of, he would be disqualified, basically. And it goes back through the same process what we spoke on before. So yeah, basically it's touching back on what was said before. So if he gave up his Commonwealth citizenship exceeding 6 months, if he vacates the seat, granted a free pardon, if he got a reduced sentence, all of that, but as long as he's convicted of this, basically all the things that would make that person not be given the post in the first place, they shall be classified vacant if they fail to meet all these criteria. Yeah, so it's for the purpose of this section. Persons serving more than 2 consecutive terms exceeding 6 months shall not be, yeah. Okay, so basically just going over the same thing. So there are set criteria basically of what qualifies you to be an MP. As I said, financial readiness, mental stability, clean criminal record, Commonwealth/Jamaican citizenship, no dual allegiance or allegiance to anywhere else. So those 5 criteria, and also not having a government contract with a legally or business relation. So those 6 criteria, failure to meet all these 6 criteria or failure to meet even one of them will render you ineligible, 1, or 2, it will render you, if you were eligible and those factors change, you will become ineligible, hence making your seat vacant. Alright, so trying to clarify that part there. Moving on to the second point, this is point 42. President and Deputy President of the Senate. Well, the Senate first meets after dissolution of Parliament and before it proceeds to dispatch any other business, it shall elect a senator, not being a minister or a parliamentary secretary, to be president. Whenever the office of president is vacant, otherwise than by a reason of dissolution of parliament, the Senate shall not later than its second sitting after vacating vacancy as a reason elect any other such senator to fill that office. So the president of the Senate shall not be a minister or a parliamentary secretary. So they can be having a ministerial offices as in Minister of Education, Minister of Finance. I shall not be a parliamentary secretary. And this is that president, when the parliament is dissolved, shall be elected in the first sitting, and no later than the second sitting. So if he's get elected in the first sitting, right? And if there is any change by the second sitting, that change has to take place, or no other senator can take the post of second president. And they get two chances. First week, they have to elect him. Second week, if they want to replace him, that's that. Third week, it's final. Upon the president being elected before he enters upon his duty of office, he shall, unless already done in accordance with provisions of Section 62 of the Constitution, make subscribe before the Senate the oath of allegiance. Next point, when the Senate first meet, any dissolution of Parliament shall soon practicable elect one of his members, not being a minister, secretary, or deputy president, and whenever the office of deputy president becomes vacant, the Senate shall, as soon as convenient, elect another member to fill that office. A person shall vacate the office of president or deputy president if A, he resigns, C, cease to be a member of Senate, provided that the president or deputy Senate ceases to be a member by reason of dissolution of parliament, shall be deemed to continue in office for the purposes of section 47 of this constitution until he resigns his office or vacates otherwise reason of dissolution of parliament, or until office of president, or that case maybe the president is filled. So basically, if the president or deputy president cease to be a member of the Senate, as in they resign or just give it up in terms of not fulfilling the duties. However, in the dissolution of parliament, they can also go back to being the president of the Senate in that role, because the dissolution of parliament is not upon the president's will. It just happens, it's a formality basically. So he can resume that seat had he been elected, or if someone otherwise is elected. That is for both the president and deputy president. And if he's appointed a minister or a parliamentary secretary, basically, which will make him no longer be able to be the Senate president, basically, because it's a conflict that that's one of the reasons you couldn't get to be if you're a minister or parliamentary secretary. So if he's appointed as such, you'd have to give up the Senate president post, and in that instance, the deputy president would be president if elected in that role, basically. So he'll be acting as the president, and if he's elected, he will then become the Senate president. So, 43, Speaker and Deputy Speaker of the House of Representatives. When Parliament first meets after any dissolution of Parliament and before it proceeds to dispatch of any other business, it shall elect one of its members, not being a Minister of Parliament or a Parliamentary Secretary, to be Speaker, and whenever the office of Speaker is vacant, otherwise than any reason of dissolution of Parliament, the House of Representatives shall no later than its second sitting, after vacancy has arisen, elect another such member to fill that office. Upon the Speaker being elected and before he enters upon the duties of his office shall, unless he has already done so in accordance with the provisions of 62, make and subscribe before the House of Representatives an oath of allegiance. When the House of Representatives first meets after any dissolution of Parliament, it shall, as soon as practicable, elect one of its members, not being a parliamentary secretary, a minister, or a deputy speaker, to be deputy speaker, sorry. So the same format applies for the speaker and it also applies for the speaker. This person should not be a parliamentary secretary or a government minister with portfolio. A person shall vacate the office of speaker or deputy speaker if he resigns that office or ceases to be a member of the House of Representatives. If he's appointed a minister or a parliamentary secretary, in that case, the deputy speaker, if elected, shall be the speaker. 44, we're at 44 now. 44 section of the Constitution, and we're still under Parliament, basically. So it says 44. Determination of the question as to membership. Any question whether any person had been validly elected or appointed as a member of either the House or any member of the House has vacated his seat therein or is required to, under provisions of Section 3 or Section 4 of Section 41 of this Constitution, cease to exercise any of his function as a member shall be determined by the Supreme Court or on appeal by the Court of Appeal, whose decision shall be final in accordance with the provisions of any law for that time being forced in Jamaica, subject to any such law in accordance with any direction given in that behalf by the Chief Justice. Proceeding for the determination of any question referred to in Section 1 of this section shall be instituted by any person, including the Attorney General, where such proceedings are instituted by a person other than Attorney General. The Attorney General will, if he is not a party thereto, may intervene. If he intervenes, may appear to be represented therein. This part is 45, section 45, filling of vacancies. Whenever a seat of a member of Senate becomes vacant, the Governor General by shall instrument under the broad seal appoint to fill the vacancy. A person shall qualify in accordance to the Constitution for appointment of senators. In making such an appointment, the Governor General shall, in any case where the member whose seat has become vacant was appointed on the advice of the Prime Minister, act in accordance with the advice of the Prime Minister and was appointed on the advice of the Leader of the Opposition, act in accordance with the advice of the Leader of the Opposition. So basically, when the senators are vacant and they re-elect someone, they shall be elected by basically the Prime Minister and Leader of Opposition respectively, and shall act in accordance with the wishes of such Leader of Government and Leader of Opposition. So basically, when a bill is an idea what you want to become a law, when a bill is passed, tabled in Parliament, and it's passed to the Senate, right? So that the vote on it in the House of Representatives, if the bill is passed, it's voted on in the Senate. The senators shall act in accordance to the wishes of their respective party leaders, basically. So if the opposition says yes to the bill and the government also says yes to the bill, both the opposition and government senators should, in fact, say yes to that bill and it shall be passed and put into law, basically. That's what that is saying. Unqualified persons for sitting or voting. Any person who sits or votes in either house knowing or having reasonable ground for knowing that he is not entitled to do so shall be liable to a penalty of £10 for each day in which he sits or votes. So £10, that's like, all right, £10, that's like £1,000, well, like call £10 $1,000, right? Or maybe that's a $2,000. So if I'm sitting in Parliament for a year, that's 2,000 times 354. That's like $75,000. $75,000 basically for a year. So that's not such a hefty fine because £10 per day, that's $2,000 a day, and that's like $75,000, right? So if I ineligible be a member of parliament, all I have to do is pay a fine of £10 a day. So I could basically be in parliament for 1 year and pay a levy of 75,000 Jamaican dollars after being ineligible to do so, knowing that I am not eligible and still sitting and possibly reaping the benefits of that office, presuming that person still gets paid. Any such penalty shall be recoverable by civil action in the Supreme Court that sues Attorney General. So they can also claim back that money. And it's quoted in pounds, which is strange to me. Because why would they still quote it in £10? Anyways, for example, clerks to the House of Parliament and their staff. The offices of clerk and deputy clerk of the Senate are hereby constituted, and appointments of those offices shall be made by the Governor General, acting on the recommendation of the President, Senate President, or the Parliamentary President, basically. The office of clerk and deputy clerk of the House of Representatives hereby constituted. The appointments of those offices shall be made by the Governor General acting under recommendation of the Speaker. So the Speaker of the House of Parliament is basically the Parliamentary President. I hope I'm right about that. Subject to the provisions of Jamaica subsection 5 of the section, clerk shall be, unless he sooner resigns the office or holds the office, attains the age of 65 years, or such later years age may be in particular case be prescribed of a commission appointed under subsection 7 of this section. Nothing being done by the clerk shall be invalid by reason that he has attained the age at which he is required to vacate the office by this section. The clerk shall be removed from office by the Governor General if but shall not be removed unless the House, by resolution which has received the affirmative vote of not less than 2/3 of all the members thereof, has resolved that ought to be removed in inability to discharge functions of his office, whether arising from infirmity of body or mind, or other cause or for misbehavior. So it says, the clerk shall not be removed, even if he reaches the age in which he shall vacate, unless there is a 2/3 majority of votes rendering that person mentally unfit, physically unfit, or causing misbehavior and malpractices. Those are the grounds on which the clerk can be removed. And those provisions also apply to the deputy clerk. Subject to provisions of Sector 3, 5, 6, and 9 of this section, terms of service, including salary and allowance of the clerk and deputy clerk, shall be determined from time to time by commission consulting the following persons, that is to say, Speaker as chairman, president, minister responsible for finance, or person nominated by a minister representing him at any meeting of the commission. The salaries and allowance of the clerk and deputy clerk shall be paid out of the consolidated fund, and no such salary shall be reduced during the continuance of the office of the person to whom it is payable. So you cannot reduce the wage or salary if the person already took office, basically. A person who is a public officer without ceasing to hold that office in the public service be appointed in accordance with the provisions of this section to the office of deputy clerk, but no such person appointed shall be except with the concurrence of the Governor General Act on recommendation of the Public Service Commission. An officer so appointed shall not, during his continuance of office, deputy clerk or clerk, perform the functions of any public office. An officer so appointed may at any time be appointed by the Governor General, acting on the advice of the Public Service Commission, to assume or resume function of a public officer, and he shall thereupon vacate his office as clerk or deputy clerk, but no appointment under this paragraph shall be made without the concurrence of president or speaker, as the case may be. The Governor General, acting on representation and the recommendation of minister responsible for finance, after that minister consult the clerk, may from time to time prescribe by notice published in the Gazette the office of deputy clerk, which constitutes staff of clerk, and may likewise prescribe which of those offices are subordinate offices. How to make appointments to any office for a time being prescribed under section 11 of this section as a subordinate office on that staff, the clerk, and to remove the exercise disciplinary control over a person holding or acting in any such offices is hereby vested in the clerk. Before the Public Service Commission advises the Governor General under section 5 of subsection 1 of section 125 of the Constitution, any person should be appointed to the office on the staff of clerk other than the office of deputy clerk and any subordinate office thereon. That person holding or acting in any such office shall be appointed by other public officer, or that person holding or acting in such office shall be removed, or that any penalty be imposed on him by way of disciplinary control. The commission shall consult the clerk. Next point. Nothing in this section shall be construed as preventing the appointment of one person to office of clerk of Senate or clerk of House of Representatives, or appointment of one person to the office of deputy clerk of the Senate or deputy clerk of House of Representatives. The appointment of one person to any other office on the staff of clerk of Senate or any other office on staff of clerk or House of Representatives, and where any person is so appointed to offices, the foregoing provisions of this section shall apply in relation to him in respect of each office separately. Next point, 15. The functions conferred by this section on the president shall, if there is no person holding the office of president, or if the president is absent from Jamaica or otherwise unable to perform those functions be performed by deputy president and the function conferred by this section. Speaker, if there is no person holding the office of speaker, or if the speaker is absent from Jamaica, is otherwise unable to perform those functions, be performed by the deputy speaker. So that was part one of Parliament, right? And now we're going to part two of Parliament. So at this point again, take a water break before we delve into the second part. I'm going right into it. Power to make laws. First point. Subject to the provisions of the Constitution, Parliament may make laws for the peace, order, and good governance of Jamaica. Second, without prejudice to generality of subsection 1 and subject to the provisions of 3, 4, and 5 of this section, Parliament may, by law, determine the privilege and immunities and powers of the two houses and members thereof. 3. No civil or criminal proceedings may be instituted against any member of either house for words spoken before or written in a report to the house of which he is a member, or to a community thereof, or any other joint committee, both houses, by reason of any matter or thing brought by him therein by petition, bill, resolution, motion, or otherwise. 4. For the duration of any session, members of both houses shall enjoy freedom to arrest freedom from arrest for any civil debt except debt of contraction which constitutes a criminal offense. 5. No process issued by any court in exercise of its civil jurisdiction shall be served or executed within the precinct of either house, while such house is in sitting, or through the president or speaker, the clerk, or any officer of either house. 49. Alteration of this constitution. Point 1. Subject to the provisions of this section, Parliament may, by Act of Parliament, pass by both houses, alter any provisions of this constitution, or in so far as it forms part of the law of Jamaica in any provision of Jamaica's Independence Act of 1962, in so far as it alters. And it goes through a list of sections, so it can be altered. Alteration of the Constitution, it can alter the following sections. It says sections 13 through 26. Basically, it says sections 66 to 67, section 60, sections 82 to 91, and there's a long list because it even says section 112 to 120. Says section 126 to 136, basically. So all those sections of this constitution can be altered. B. Section 1 of this constitution, in its application to any of the provisions specified in paragraph A of this subsection. That's what we just spoke about this time. Bill, next point, bill for an act of parliament under this section shall not be submitted to the Governor General or for his assent unless a period of 3 months has elapsed between the introduction of the bill into the House of Representatives. So it takes 3 months for the bill to be granted because they're passed into law. Commencement of the first debate in the House text of that bill. The House a further period of 3 months which elapsed between the consultation conclusion of that debate and the passing of the bill by the House. Insofar as it alters these sections, and it goes into this section that it alters. It says a bill for an act of parliament under this section shall be determined a bill for an act of parliament under this section shall not be deemed to be passed in either house at the final vote thereon. It is supported in the case of a bill which alters any of the provisions specified in sections 2, subsections 3, for the section by votes, if not less than 2/3 of all the members of the House, or in any case by the votes of majority of all members of that House. If a bill for an act of parliament which alters any of the provisions specified in subsection 2 of the section passed by the House of Representatives, A, twice in the same section in the manner prescribed at least 7 months before. So if you just change it, you can change it back within 7 months. You have to wait. Or if it's rejected by the Senate, it can't be passed yet. If in 2 successive sessions it has not been passed, you can't retable that bill until 6 months has passed on the first occasion and it has been rejected. So, say a bill passed in the House of Representatives January, you'd have to wait until July to try and pass that same bill. You can't just try and put it in, pass the bill this month and it rejected and try and pass it back in 2 months from now. You have to wait until 6 months have passed this time. That bill may not less than 2 nor more than 6 after its rejection by Senate for a second time is submitted to the electors qualified to vote for election of member House of Representatives, and if on a vote taken in such manner as Parliament may prescribe, 3/5 of elected votes approve the bill may be presented to the Governor General for assent. So basically 3/5 of the House have to vote to send that bill to the Governor General. So that's like 60%. So you have to have a majority vote to send it to at least 3/5 majority. It's like 60% basically to send it to the Governor General's office. This is for the purposes of subsection 5 and subsection 6 of this section. The bill shall be deemed to be rejected by the Senate if it has not been passed by the Senate in a manner prescribed in the paragraph of subsection 4 of this section within 1 month after it is sent to the House. So the Senate have 1 month to deliberate on a bill that has been tabled in the House of Representatives and sent to the Senate. If it has passed 1 month and no decision has been made on it, so they withhold their vote, it shall be seen as rejected by the Senate. So basically they don't pay it anymore. If it is passed by the Senate in a matter so prescribed to which any amendment which is not agreed on by the House of Representatives. So if they pass a bill to the Senate and the Senate approves it, yet they make amendments to it, the amendments will still have to be approved by the House of Representatives, or it still it can't be passed into law until the House then goes and agrees with those amendments to the bill. Amendments are alterations basically. So if the House sends a bill to the Senate the Senate agrees with it, however, they alter it and put in other clauses in it, it would have to be sent back to the House of Representatives for them to have a debate or discuss it and see if those terms are acceptable. Then it would be sent back to the Senate and they would do a similar thing. And if it's passed in that Senate, it will go to the Governor General, and the Governor General still would have to approve it basically. But typically he would, if it's constitution. But purposes of Section 5 and Section 6 bill have been sent to the Senate from the House of Representatives in any session shall be deemed to be the same bill as the former bill. Sent to the Senate in same or preceding session. If when it is sent to the Senate, it's identical with the former bill or contains such alteration that are specified by the Senate to be necessary owing to the time it has elapsed since the date of the former bill to represent any amendment which shall be made by the Senate of the former bill. So if they send the bill, it shall be considered as the same bill basically, as long as there's no alteration, or even if the alterations were noted by the Senate, it should be classified as the same thing. Section 51, regulation of the procedure in House of Parliament. Subject to the provision of this Constitution, each House may regulate its own procedure for this purpose. May make standing orders. Each House may act notwithstanding any vacancies in its membership, including any vacancies not filled when the House persons are on or after the appointment day or after any dissolution of Parliament, and the presence or participation of any person not entitled to be present at or to participate in proceedings of the House shall not invalidate those proceedings. So if they were scheduled to be in the House and they're not in there, Parliament will go on as usual basically. So what's that saying? Section 52, presiding in Parliament, in Senate and House of Representatives. The President, or in his absence, the Deputy President, or if they are both absent, a member of the Senate, not being a member of Parliament Secretary, elected by the Senate, for that sitting shall preside at each sitting of the Senate. The Speaker, or in his absence, the Deputy Speaker, if they are both absent, a member of the House of Representatives, not being a minister or parliamentary secretary, elected by the House of Representatives for that sitting shall preside at each sitting of the House of Representatives. Reference in this section to circumstances in which the President, Deputy Secretary, Deputy President, Speaker, Deputy Speaker is absent include reference to circumstances in which the office of President, Deputy President, Speaker, Deputy Speaker is vacant. Quorum. This is 153. If at any time during a sitting of either House, objection is taken by a member that there is not quorum present, and after such interval may be prescribed in standing orders of that House. The person presiding ascertains that there is still not a quorum present. He shall thereupon adjourn the House. For the purposes of this section, a quorum of Senate shall consist of 8 members besides the persons presiding. A quorum House of Representatives shall consist of 60 members beside the person presiding. Alright, so the Parliament, with a House of Representatives or Senate, have a minimum number before a meeting or a sitting can be held. For the Senate, it's 8, and for the Parliament, it's 16, and that's fair. I don't see why there should be a parliamentary sitting with less than 16 members there. These are minimum quota because what they would be talking about if most if so much members, it could be a finance minister absent or a lot of members absent because what 16 from 21 that would be 5 sitting members absent, and as it relates to the no that's Senate 8 from 21 that would definitely be like majority absent basically because there would be 13 people absent from Senate, and if 16 members of the House are present, that would make 50 members absent basically. And if 50 members of parliament are absent, I don't say the, the the validity of the parliament basically because most of the MPs of the country won't be sitting in the parliament. They just have 16 constituencies. 16 constituencies can be just Kingston and St. Andrew. What if something happens and the road is blocked or something like that and no one can get into parliament? That would just basically be a meeting of the members of the KSAC committee basically. Uh, Section 51 says voting. Alright. First point. Same as is otherwise provided in this constitution, all questions proposed for decision in either house shall be determined by a majority of the votes of the members thereof present and voting. Oh, so the vote basically is counted as a percentage of the members present at the time and not the overall members in the house. The person presiding in either house shall not. The person presiding in either house shall not vote unless any question in the vote are equally divided, in which case he shall exercise of the exercise of casting a vote or except the case of the final vote on the bill of parliament under subsection 3 of section 37 and 39 of this constitution. The final vote on the bill or an act of parliament of section 50 of this constitution refers to in each of the cases shall have an original vote. So that's that. All right, so the next section is section 55, introduction of bills, etc. Subject to the provisions of the Constitution, sitting and the standards of the House, any member of either House may introduce any bill or propose any motion for debate in or may present any petition to that House, and the same shall be debated and proposed in accordance to the standing orders of the House. A bill other than a money bill may be introduced in either house, but a money bill shall not be introduced in the Senate, except on recommendation of the Governor General, signified by a minister of the House of Representatives, shall not proceed upon any bill including any amendment to a bill, which bill or amendment, as the case may be, in the opinion of the person presiding, makes provision for any of the following purposes, that is to say, for imposing or increasing any tax, or for imposing or increasing any charges or revenues or other funds of Jamaica, or for altering such charge otherwise than by reducing it, for compounding and remitting any debt due to Jamaica. Proceeding on any motion, including amendment to any motion, the effects of which motion or amendment, as the case may be, in opinion of the person presiding, is the provision should be made for any purpose aforesaid or receive any petition which, in the opinion of the person presiding, requests that provision may be made for the purposes aforesaid. The Senate shall not proceed upon any bill other than bills sent from the House of Representatives, or upon any amendment to the bill which bill amends or the case may be. The opinion of the person presiding makes the provision for any following purposes, that is to say, for imposing, altering, or existing proposed tax, or imposing, altering, or existing or proposed charge on revenue or other funds of Jamaica, or compounding or remitting any debt due to Jamaica. Proceed upon any motion, including any amendment to a motion, the effects of which motion or amendment, as the case may be, in opinion of the person presiding, is the provision should be made for any of the purposes aforesaid, or receive any petition which, in the opinion of the person presiding, requests that provision be made for purposes aforesaid. And section 53, restriction on powers of Senate as to money bills. Subject to provisions of this Constitution, if a money bill has been passed in the House of Representatives and sent to the Senate at least 1 month before the end of session, it shall not be passed by the Senate without amendment within a month after it's sent to the House. Bills shall not, unless the House of Representatives otherwise resolve, be presented to the Governor General or his Senate, notwithstanding that the Senate has not consented to the bill. There shall be endorsed on every money bill when it is sent to the Senate. The certificate of the Speaker signed by him that it's a money bill, and there shall be endorsed on any money bill presented to the General for assent. In pursuance of section 1 of this section, certified speaker signed by him that it's a money bill, and the provisions of that subsection shall be complied with. So the Senate, I don't think they have much to do with like money bills. They just send them from the House. It's signed by the Speaker of Senate and it goes straight to the Governor General. That's what I get from that, basically. And 57 says, restriction on powers of Senate as to bills other than money bills or certain other bills, basically. 1. Subject to the provisions of this Constitution, if any bill other than a money bill is passed by the House of Representatives, A, twice in the same session, having been sent to the Senate on first occasion at least 7 months before the end of the session, and on the second occasion at least 1 month before the end of the session, is rejected by the Senate or on each occasion. In two successive sessions, whether of the same parliament or not having been sent to the Senate in each of those sessions at 1 month before the end of the session. Second session being at the last 6 months after the first occasion, at least 6 months after the first occasion, is rejected by the Senate in each of those sessions. So it don't matter which government composition is in the House at that time. Basically, the Senate doesn't view it, just views the time period. So even if it's a new government, this bill is still seen as the same, and it will not be passed until the time frame, or not be viewed until the time frame has passed. It should be submitted within a certain window. For the purposes of this section, a bill sent to the Senate from the form to be the same as the former bill, identical to the former bill. We basically just showed that already. So if it is the same type bill, it's just viewed as the same or identical. There shall be inserted any bill is presented to the Governor General by assent in pursuance to section. Any amendment that are certified by the Speaker have been made in that bill by the Senate, agreed to by the House. There shall be endorsed on any bill that is presented to the Governor General for assent in pursuance of this section, the certificate of the Speaker signed by him that the provisions of this section have been complied with. Provisions of this section shall not apply to a bill which is required by this constitution to be passed by both houses. Says section 58 says provisions relating to sections 55, 56, and 57. In the constitution, the money bill means public bill which, in opinion of the speaker, contains only provision dealing with or of the following matters, namely imposition of payment or debt or financial purposes charged on consolidated fund or any other public fund or monies provided by Parliament, or the variation or repeal of such charges, the grant of money to the Crown or any authority or person, or the variation of revocation or any such grant, appropriation received or custody, investment issue or audits of account of public money, raising guarantee of any loan, repayment thereof, or establishment, alteration, administration, or abolition of any sinking fund provided in the connection with any such loan or subordinate matter identical to any of the matters of assent. And in this subsection, the expression taxation debt, public fund, public money loan does not include any taxation imposed, debt occurred, or fund money provided or loan raised by any local authority, body, or local purposes. So it's basically dealing with monies owed to foreign countries and levies, basically tariffs and so forth, not necessarily internal. So that's what they mean by money bill. Basically a bill, literal bill. So that's just a bit of clarification there. So it's section 59, restriction of powers of Senate on certain statutory instruments. So the first point is, right, any statutory instrument to which this section applies and which having been laid before the Senate in any session at least 7 months before ending of the session is not approved by the Senate shall, if it is again laid before the Senate at least 1 month before the end of the session, or if any session at least 1 month before the end of the session is not approved by the Senate in our session, if it is again laid before the Senate at least 1 month before the end of the next succeeding session, whether the same parliament or not, but not earlier than 6 months after it is laid for the first time, deemed to be approved by the Senate at the end of the session in which it was laid for the second time, if it has not been so approved. In these sections, statutory instrument means any document which the Governor General or of the former colony of Jamaica, minister, or any executive authority exercises power to make, confirm, or approve orders or rules, regulation, or subordinate legislations. So it's just clarifying the terminologies in this chapter. Basically, this is chapter 5. Yeah, chapter 5. Under section 60 says a bill shall not become a law until the Governor General has assented thereto Her Majesty's name, and Her Majesty's behalf has signed it into token of such assent. Subject to the provisions of sections 37, 49, 50, 56, and 57, of this Constitution, a bill shall not be presented unless it had been approved by both houses of Parliament, either without amendment or such amendments only agreed to by both houses. When a bill is presented to the Governor General for assent, he shall signify that he assents or that he withholds assent. Words of enactment. Every bill presented to the Governor General for assent other than a bill or a special act defined in subsection 3 of this Constitution, a bill presented under subsection 49, 56, and 57, constitutional bill, or a bill for act of Section 50. This Constitution refers to the word enactment as follows. Be it enacted by the Queen, most excellent Majesty, by which the advice of and consent of Senate and House of Representatives of Jamaica, and by authority of the same as follows. In every bill or a special act defined in subsection 3 of Section 37 of this Constitution presented to the Governor General for assent, the words enact shall be as follows. Be it enacted by the Queen, most excellent Majesty, by and with the advice and consent of the Senate and House of Representatives of Jamaica, in accordance with the provision of Section 3 of 37 of the Constitution of Jamaica, and by the authority of the same as follows. And next point, every bill presented to the Governor General for assent under this section 49 of this Constitution, the words of enacted shall be as follows. And it basically says the same thing. Be it enacted by Queen, Most Excellent Majesty, in accordance with the advice and consent of the Senate and House of Representatives of Jamaica. Constitution of Jamaica be by the authority of same as follows, basically. So that's how it is enacted. And Section 62, Court of Religion. No member of either house shall take part in proceedings thereof other than proceedings necessary for the purposes of this section until he has made subscribe before the House an oath of allegiance, provided that the election of President or Speaker, as the case may be, may take place before the members of the House have made such subscribed oath. And part 3. So we just finished part 2 of Parliament. So we are at chapter 5, Parliament. I will do part 1, part 2, and this is part 3 of the parliamentary chapter. And it says summoning, prorogation, and dissolution. Section 63. Sessions of Parliament. Each session of Parliament shall be held at such place within Jamaica, shall commence at such time as the government may proclaim, published in the Gazette appointed. Sessions shall be held at such time so that a period of 6 months shall not intervene between the line of sittings in one occasion of the first sitting to the next. So you can't have more than 6 months passing between each sitting. Have to be regular intervals. Basically. Section 64. Prorogation and dissolution of Parliament. The Governor General may at any time, by proclamation published in the Gazette, prorogue or dissolve Parliament, subject to the provision of Section 3 of this section. Parliament, unless soon dissolved, shall continue for 5 years from the date of its first sitting. After any dissolution shall then stand dissolved. At any time when Jamaica is at war, Parliament may from time to time extend the period of 5 years specified in subsection 2 of this section for not more than 12 months at a time, provided that the life of Parliament shall not be extended under this section for more than 2 years. So the maximum time of a Parliament sitting is 5 years. However, in a time of war, crisis, it may be extended for 12 months at a time. And the maximum is 7 years, basically, until it has to be resolved. And not that the wars to go on more than 7 years, but there have been wars that last more than 7 years. So what would happen in that case, I'm not sure. And it says, if between a dissolution of Parliament and the next ensuing general election of members of House of Representatives, an emergency arises such that the nature of that, in opinion of the Prime Minister, is necessary for the two houses or either of them to be served before general election can be held, the Governor General may, by proclamation published in the Gazette, summon the two houses of that preceding Parliament, and that the Parliament thereupon meeting, except for the purposes of Section 65, not have been dissolved, but deemed, except as aforesaid, to be dissolved on the date in which qualified held for the next ensuing general election. The next point is, in the exercise of his powers under the section, Governor General shall act in accordance with the advice of the Prime Minister, provided that the House of Representatives, by a resolution which has been perceived as an affirmative vote of a majority of all the members thereof, resolve that has no confidence in the government. Governor General shall proclaim publishing the Gazette dissolved. So no confidence vote could also rule out that. And 65 is general election and appointment of senators. First point, a general election of members of House of Representatives shall held at such time within 3 months after every dissolution of Parliament, as the Governor General acting in accordance with the advice of the Prime Minister shall appoint by proclamation published in the Gazette. As soon as maybe after every general election, the Governor General shall proceed under Section 35 of the Constitution, appointment of senators. And it says, Part 4, which is delimitation of constituencies. Section 66, establishment of first constituencies until otherwise provided by order made by Governor General under Section 67 of the Constitution. Jamaica, for the purposes of election, elected members of Parliament shall be divided into 45 constituencies prescribed by the Constituency Boundary Order of 1957, made by the Governor of Jamaica, published in the Gazette of 28th day of May 1959. Every constituency established under this section, under Section 37 of this Constitution, shall return one member to the House of Representatives. And we're going now to Section 67, which what Section 66 referred to. Standing Committee of the House of Representatives. Subject to the provisions of Section 66 of this Constitution, Jamaica, for the purposes of election of members of the House, shall be divided into such number of constituencies not being less than 45, nor more than 65, as may from time to time be provided by order made by the Governor General. As soon as practicable, after the House of Representatives meets after the appointed day or following the general election, shall be established standing committee of the House consisting of the Speaker as Chairman, the 3 members of the House appointed by the Prime Minister, and 3 members of the House appointed by the opposition. It shall function as the standing committee to keep under continuous review the number of constituencies in which Jamaica is to be divided and boundaries of such constituencies. Subject to the provisions of this section, the procedure of the standing committee shall be determined by standing orders of the House of Representatives. The standing committee shall, in accordance with the provisions of the following subsections, submit to the House of Representatives reports either showing the constituencies into which it is recommended that Jamaica shall be divided, or in order to give effect to the rules set out in the second schedule of this Constitution, or also stating that in the opinion of the committee, no alteration is required in the existing number of boundaries or constituencies in order to give effect to the rules, the said rules, Under subsection 5, this section, it shall be submitted by a standing committee in the case of its first report after appointed day, not less than 4 nor more than 6 years from that day, and in the case of any subsequent report, not less than 4 nor more than 6 years before the submission of the last report. So it's a 4 to 6 year election window basically. And it says, point 7, where the standing committee intends to consider making a report, it shall, by notice in writing form, inform the minister responsible for conduct of elections. Here's when the session called the minister, according to the copy note shall be published in the Gazette. As soon as maybe after the standing committee has submitted a report to the House in the paragraph section 1, the minister shall lay before the House for its approval draft of an order by the Governor General giving effect to recommendation contained in the report, and that draft may take provisions from any matter which appears to the minister to be incidental or consequential upon provisions of the draft. Where any draft made under this section gives effect to any such recommendation with modifications, the minister shall lay before the House together with the draft and statement for the reason of modification. If the motion for the approval of any draft made under this section is rejected by the House of Representatives or is withdrawn by leave from that House, the minister shall amend the draft and lay the amendment draft before the House of Representatives. If any draft made under this section is approved by resolution of the House, the minister shall submit it to the Governor General, who shall make it an order which shall be published by Gazette. In terms of the draft, and that order shall come into force on such day as may be specified here, and until a vote by further order made by Governor General in accordance with the provision of this section shall have the force of law, provided that the coming into force of any such order shall not affect any election of House of Representatives until a proclamation is made by the Governor General, appointing the date holding for the general election of a member of House of Representatives, or affecting the constitution of the House of Representatives until the dissolution of Parliament then has begun. An Act of Parliament may provide the institution of proceeding in the Supreme Court for the purposes of determining whether or not the report is made under Section 5. This section, giving subject to provision of any act to which subsection 12 of this section refers to, the question of validity of any other order by the Governor General reporting to be made under this section, and decided that a draft thereof has been approved by a resolution of the House of Representatives shall not be inquired into any court. So basically, we've come to the end of chapter 5. We have very meaty chapter. It dealt with both the executive arm of government, both the House of Senate and the House of Representatives, talk about the validity of a person and the vacating of offices, and even touch on some of the responsibilities in terms of tabling bills and sitting and all the legalities that constitute sitting and quotas for sitting and all that. So basically finishing the chapter for Parliament, and the next chapter would be executive powers, but we'll touch on that next time. Yeah. We're looking forward to learn more. So until next time.